Good evening, everybody. This is Jonathan. I hope you guys are all doing very, very well. I am back in my home office, as you can tell. I'm not on vacation anymore. We were in the Charleston area last week, and so I did the live stream from there with probably not the greatest internet connection. So hopefully we'll be a little more clear tonight. You can tell I badly need a haircut, which I'm getting on Friday, but again, you get me all shaggy. So I hope, and somebody asked me, did I have any good meals? A lot of pizza, a lot of ice cream. We did have one really nice meal. Went to a place called, oh boy, I'm trying to remember. Anyway, it was downtown Charleston. It was quite good. It was a Hanks. It was called Hanks, and my son and daughter and son-in-law took my wife and myself out to dinner. It was our anniversary, so they paid, which was a really nice surprise, and made the meal even better. Which I'd done beforehand. I would have ordered something more expensive, but it is what it is. So anyway, but I'll remember that for next year. That's for sure. Okay, so we've already got some questions that came in. John Calamus wanted to know about trial work period. Can someone work part-time and use trial work period while waiting for a decision, or they need to be off work for 12 months? The answer is you can use trial work period as of the date of onset. So in other words, literally, if you file for disability and you say my onset date was May 15th of 2024, and you go back to work part-time May 16th of 2024, and you go use up your trial, you have some months where you're below trial work period, some months where you're above it, you can actually use your trial work period before you even get approved. So the trial work period applies as of the onset date. Now, obviously, and I've actually had situations where I had a client not too long ago who filed for disability, had to go back to work because he had to eat, had to support his family, and the judge basically counted, and he was over SGA, although he had significant medical problems. And the judge in this case, a really nice judge, what she did was she called the first 9 months and he didn't go back right away, but he went back after, let's say, a year and a half. The first 9 months of his work were trial work period. Then the next 3 or 4 months over SGA, substantial gainful activity, she called an unsuccessful work attempt. So basically, she gave this guy an extra year of benefits, and that's pretty rare, but it can happen. But as far as the trial work period, you don't need to be approved. It doesn't, there's no time limit on it. Literally, as of the minute you claim that you are disabled, as of your onset date, you can start using your trial work period. That being said, obviously, if you go ahead and use your trial work period right away, and you're working as of the time you apply, you may have to answer the question, do you have capacity to work? So I don't necessarily recommend it, but if you have to eat, you got to eat. So, generally speaking, what I tell people is if you can avoid working, that's probably better for Social Security purposes, not necessarily better for your mental health, but better for Social Security purposes. If you have to go back to work, try to keep your earnings below the $1,110, 2024 figures trial work period. And if you can't do that, try to keep it below SGA. If you go over SGA, technically for more than 6 months, and $1,550 a month, which is like $18,000 a year, is SGA in 2024. If you go over SGA for more than 6 months, you're not going to win. I mean, they're going to basically find that you've worked. And I think that, if you go over SGA, even for 4 or 5 months, that's probably problematic. So I would tell you, the less work you can do, the better. And if you can keep it below trial work period, that would be preferable. Okay, SA says, I have had family medical leave since 2006, 4 absences of 3 days, absence a month, yearly renewal. If it includes no restrictions, is this more harmful, beneficial to the SSI claim? I think, again, anytime you can show you're not reliable, and realize for vocational witness purposes, if you have a situation where you're missing 3 days of work a month on a regular basis, that is an unacceptable amount of absences from work. Generally speaking, most vocational witnesses will say that 1 or 2 days of work a month is excessive, number one, or they'll say that being off task for 15% of the workday is excessive. But if you have had if you have 3 or more days of work a month every month, that would be considered excessive, and family medical leave is kind of an accommodation. So I think that, that would show that you're really not performing work at a level that would be competitive. Now, they're going to also look at your earnings. So if your earnings are over SGA, that's going to override that. But if you're below SGA and you're missing 3 days of work a month, I think that would make your case stronger. And again, this is another situation where if you're under SGA, but let's say around the trial work period or just over that, you could argue that your work is not SGA because you're missing 3 days of work a month and you need an accommodation. And I think you've got these other type of things: 27-year job, back pain, facet arthritis, bulging lumbar discs. So, lumbar discs. So again, I think medically you're looking pretty good. And if you stopped working, I think your case is pretty strong. Christina is a regular, and she says hello from California. And hello, Christina. Nice to see you again. GI Jose, who I believe gave me some names of some restaurants in Charleston. Do ALJ decisions that are favorable come in sooner than unfavorable? No difference. I think that in fact, I've had decision writers, and if you go to my a podcast at ssdradio.com, I had a decision writer named Spencer Bishens, and Spencer basically said, he used to write decisions. He said that the favorable ones took more time than the unfavorable because the judge had to justify him or herself and really go through the evidence. So in his opinion, the favorable ones took longer. But my experience has been that the writers are going to be as busy as they are going to be, and there's no difference whatsoever between a case that's approved, that's a decision issued in 3 or 4 weeks and 3 or 4 months. It really just depends on how busy the decision writers are. Every once in a while, a fast decision could be kind of the written part of it can be sort of kind of shortcutted, I guess, as it were, if the person clearly meets a listing or a grid rule. But I would not make any blanket statements that the amount of time it takes means anything at all. And he asks, how was my vacation? I tried a new food spot. And yes, again, we did try Hank's. We did have several places we had pizza at. There's a cookie place down in Charleston. I can't remember the name of it, but they're tiny little cookies that I definitely tested, and they're not poisonous. Good news, I can tell you. They're very, very good. And my wife is a very good cook, and she cooked some fish a couple of nights. We had my grandbaby, so my daughter and son-in-law went out to dinner, so we watched the baby a couple of times and brought in, again, just fish and eggplant parm. So we're not real big going out to eat every single night. I think that we try to eat healthy, and again, my wife's a really good cook, and like I said, if anything, we probably ate more pizza and eggplant parm, things like that, than we normally would. But we did have that one really good meal at Hank's, so that was really nice to do that. All right, Jim is another regular. ALJ hearing in November. SSA sent you forms to fill out to see if you can be approved before they schedule the hearing. How do they do this? I filled out medication, work history, and doctor's info like 10 times. The forms you're talking about are the medication list, the work history, and the recent medical treatment. And they're not really there to help them decide whether you can be approved early. They're just there to update to see if there's anything new. Obviously, medications can change month to month, so they want to see if there's any new medications. Work history is not going to change, but they ask for that again because realize this is a big agency, and some people have not filled it out before, so they just send you the form. So just if you have a copy of what you sent before, just send that back in. And recent medical treatment, again, could be new. So this is just to make sure the file is updated. It is frustrating that they give you these forms over and over and over. A cynic would say this is kind of busy work for you to do to stop you from complaining to your congressperson, but it is what it is. So that's just my take, but I think you just want to make sure you get those filled out. And I always tell people, if you can, go ahead and save the ones from before, so that you've got them in case you need them again. Okay, Christine, 56 years old, which is good because it means you're potentially in grid rule territory with a physical impairment, which you do have. Chronic pain med, radiculopathy with failed back syndrome, a spinal stem, still pain with sitting and standing, can't get my surgeon to add limitations to my record. PCP will document. I think you've got a good case. I think that even if your surgeon will not document, if your PCP will, That's more than enough, I think, given that you're 56, you've got filled back, you've got a spinal stem, you're in chronic pain, you're in pain management. It used to be, I felt very strongly, you really had to have a functional capacity form or a narrative report. I don't think that as much anymore. I think that many doctors won't fill out forms, but you've got a good case. I think that assuming the medical is what you say it is, and there's evidence that your back surgery was not successful, I think you are in really good shape and you should win. That's my take. Christina says, please don't forget to like, share, comment, and subscribe. Absolutely. You can leave comments, here if you would like to. I think let me put it up here. You can subscribe. You can put in here if you'd like to leave me a review. That's always very, very much appreciated. And of course, if you want a case evaluation, you can do so at this link. But thank you, Christina, for reminding everybody of that. I really appreciate it. St. Louis Grand, another regular, one of two, okay? Thoughts and experience on reopening a claim as opposed to filing for recon, filing a new claim in response to denial. For reference, reopening is addressed in the POMS, reopening a final decision. When we talk about reopening, there's a couple things that come to mind is if you apply and you are denied and you don't appeal and you reapply within 12 months of that initial decision, you can ask Social Security or the judge to reopen your prior application. It's got to be done within a year of the initial application denial. Technically, you can go up to 4 years if you can prove that Social Security somehow misled you. But that's really, really hard to do. And I will also tell you that judges are, I'd say 60% of the time reluctant to reopen a prior application. So everything else being equal, if you have an active application, you're much better off filing for reconsideration, appealing it, as opposed to filing a new application and asking for it to be reopened. It can happen, but it is much more rare. Now, if you're talking about reopening a claim after an ALJ decision, again, you've got the 60 days to file the appeal to the appeals council. But if you're talking about going back to the judge, I've never seen that happen. I guess it could theoretically, but generally speaking, you want to pay a lot of attention to that 60-day deadline and get your appeals filed within that 60 days. So I hope that answers your question, St. Louis. I don't know if I've got you, if you're asking exactly what I'm talking about, but again, reopening, generally speaking, is within 1 year of the initial denial. That's the context that I see it in. Farron Miles, can sleep apnea be secondary to bipolar pulmonary embolism, both post-phlebitic syndrome, right, left lower extremity, tricuspid regurgitation, painful scars, left, right extremities? Yeah, absolutely. And I think I've mentioned before that I don't believe, my experience has been that sleep apnea is really, really hard to win if that's your primary diagnosis. But it adds to the puzzle, because what sleep apnea generally is going to do is it's going to limit your what they call restorative sleep. And that means that, when you go to sleep, make sure I'm going to this up, when you go to sleep and you get 8 hours a night and you wake up and you feel refreshed, then you're ready to focus and concentrate on the day and your job. If you get 3 or 4 hours of broken sleep and you just don't feel refreshed at all, what that can mean vocationally is that you don't have the capacity to do complex work, multitasking, fast-paced work environment, changes in the work site, and that chips away at the number of potential jobs that are out there. So I do think that sleep apnea can limit a restorative sleep. So absolutely, that can be a factor, but again, probably not a main factor, in my opinion. Big One says, hello everyone, hello Big One. Jan says, I was found disabled in Florida under SSA listing 1.16 and 3.01 by DDS, the Disability Determination Services. By state Medicaid application, they still deny me SSI, stating I'm not disabled. So you're saying that the state Medicaid found you disabled under a Social Security listing, but Social Security is not buying that. And I think the issue there is a couple of comments. One is that Social Security is not bound by a state, another agency, whether it's the VA or federal retirement system or disability system or a state agency. So they're not bound by any of that. So that's one point. So even though it doesn't make any sense that agency one would not give full faith and credit to another agency's determination, they don't. Second thing is that it's really hard to win a disability case in Social Security under the listings. You've got to really have significant impairments. And it's very possible that the Florida state Medicaid application had a different standard, or the people that are making those decisions are in a different frame of reference, frame of mind. But it does say to me, if you've got somebody saying you made a listing, that's pretty serious. So as you appeal, you probably have a good argument that you either meet a grid rule perhaps, or that your functional capacity has been so reduced that you would not be reliable in any kind of work. But it is not binding. The other agency's determination is not binding on Social Security. Again, you would think that there would be some reciprocity, but there is not, unfortunately. So again, if it's a state agency for Medicaid, it's, even though it may seem like it's the same people, the standard to become eligible for Medicaid may be different, and maybe they reference the listing, but again, Social Security is not really bound by that. Although you think, again, the same agency making the decision, a different person, it's very possible the definitions are a little bit different. But again, that's just my supposition. I mean, obviously the proof is in the pudding. They didn't approve you. Rick Torres, I got approved for SSA partial. We don't get partial. You maybe, you got your onset date changed. That's what you mean. You have a partially favorable decision. You don't get partial. You don't get like 85% disabled or 70% disabled. Either you are or you're not. But the date on it obviously was changed. So, what the Social Security did was they approved you, but said instead of being approved as of, April of 2021, you're approved as of October of 2023. Eliminates a lot of past due benefits, a lot of money, but you're not going to take that chance. On the counterpoint of that, and I've had a number of these cases, you could also make the argument if the state agency saw enough in your case to find you disabled, and you appeal it, is there really a lot of risk? Because the state agency doesn't approve a lot of cases early. If they did, the real risk is you get in front of a judge who's just unreasonable and approves 10% of cases. That's the risk. If you get in front of a reasonable judge, I think the risk is probably minimal. But again, if you depend on this money to survive and you want your Medicare, you may decide it's just not worth the risk. And I think Rick decided that you want to take a chance on losing everything. There is certainly, that's a defensible and understandable type of thing. So I think John is the one who got found disabled by Medicaid. The state uses the same 5-step sequential process. They stopped on step 3 saying you made a listing and awarded Medicaid, but SSA denied. And again, I'm just throwing this out because I don't know for certain. You're talking about SSI, so it's possible you got approved for SSI, and then with SSDI, maybe you don't have enough credits. So maybe the reason you were denied for SSDI was not based on the medical, it was based on a non-medical factor of not having enough earnings credits. Possible. Number 2 would be that the Medicaid standard, the people who make decisions for Medicaid, they have a different definition of disability, even though it's the same office making that decision. I don't know, but those are the 2 things that jump out to me. St. Louis Grant, thank you very much for the $5 tip. I really appreciate that. Let's see, the claimant submitted an IMO from a doctor, and I guess that's an independent medical opinion to DDS, and that opinion is not listed in the decision, and the section that lists records used, reopen based on that. Again, what are we talking about, reopening or appealing? Again, I think that reopening, as I understand it, is discretionary. So you can certainly argue, and one of the things you do argue is that there is evidence that was not available, was not used by the original decision maker. So yes, if there is a piece of medical evidence that was available, that was submitted even, that was not used, that would be absolutely grounds to reopen. But again, you're better off appealing and going to the reconsideration as opposed to trying to reopen. But if you miss the deadline, And by the way, if you miss it by a few days, you can appeal and you can ask for good cause to have it reopened. So, it doesn't mean that, let's say you're day 70 or day 75. I've had a number of those reopened to file the reconsideration by arguing that my client, because of his or her medical condition, was not able to understand the need to get this appeal filed, or wasn't able to cooperate with me in getting it filed, or didn't understand because of cognitive issues the need to get an attorney, things like that. So, before you get into reopening, see if A, you can fit within that 60-day deadline, or B, that you can reopen within, again, 3, 4, 5 months of missing the deadline because, you have a good cause reason. And then beyond that, you would need to file a new application and then ask for that to be consolidated by reopening the old one. So that's kind of the way that is. So, I think that, Social Security, look, so 60-day deadlines are not a lot of time. And people get these decisions, and there's a lot of boilerplate and a lot of just, rigmarole in there. And you look at it and you may miss the fact that you've only got 60 days. They don't send you the appeal paperwork. They'll give you the form number, but they don't really tell you how to do it. So, it can be easy to let that 60 days go by. And I've had people call me on day 58, where I'll tell them is, go ahead and just get it filed. Here's how you do it electronically. Get it filed, get me involved after that. But, 60 days is 2 months sounds like a lot of time, but it's really not. So, look, when I get a case, we have to gather information. I can do it obviously if I have to in a day, but normally it's going to take a good week to get everything together. But if I have a deadline and somebody's retained me, they want me to do it, I'm just going to file essentially a blank form in reconsideration and supplement it later. You can do that too. You can file a very, very basic reconsideration and then supplement it later if you don't have time to get it done before the deadline. So most important thing is that if you can meet the deadline. Glenn is from Cape Cod. Never been to Cape Cod. I heard it's really nice. You watch every week despite being approved in July. Well, I'm glad you do. I hope you see some value here. I know that some of the things we talk about would be continuing disability review, or just things like that, or just all kind of stuff that happens after you get approved. And I'm glad you are here. Thank you very much. I really appreciate it. Hey, Wolf. With regard to Jim Tuski's comment about more paperwork and he may be able to avoid the ALJ hearing, do you think they're doing that for a lot of people waiting for ALJ hearings? Again, the 3 forms he talked about, K. Wolf, are the updated medications list, recent medical treatment, and work history. And they are not designed to get you approved early. Now, one thing I will say is that, as you probably know, we went from a 15-year look back to a 5-year look back with jobs. So that work form is actually very important to make sure that the dates on that are very accurate. But, the best way to get approved early would be for your attorney to file a pre-hearing brief. And I do those in almost every case. I've had cases get approved early on that where a judge will literally call me before, a day or two or the day of the hearing and say, I'm looking at your brief, I'm looking at the record, and we don't need to have a hearing. I'm like, great, that's ideal. So that would be, that. But I don't think that, filing the medications list or the work history report is designed to get you approved early. And K. Wolf says, one of the last things you're adjudicated from DDS says you're turning 60, like Universal. Realize they're the adjudicators, and I sometimes criticize them, but they work really hard. And, I've talked to a number of adjudicators you can tell want to do a good job, but they are kind of hamstrung by the fact they've got so many cases in so little time, and they request medical records that they don't come in. They've got to get these files processed. There's, if I'm not, and I don't want to say absolutely, but my understanding is there are performance metrics where they have to get these cases processed within a certain amount of time. And so if they don't have all the records, they just go ahead and make the decision. So it's a tough job. And I know that, one of the things that I look at, there's a couple of blogs that I subscribe to, and one, Charles Hall's blog. If you look up Attorney Charles Hall, Social Security blog, and it's very interesting. He talks a lot about there's some sort of a federal work site or I'm not sure, the listserv or a blog where people talk about the satisfaction of their job, or they do surveys. And unfortunately, Social Security usually ends up kind of at the bottom of the heap. And a lot of people that work for Social Security that are good are poached away by their agencies. That being said, the current commissioner, Commissioner O'Malley, is doing a really, really good job. And I credit him for really trying to make some substantive changes. We'll see how long he's there. But he is a good man. I had a chance to see him speak in Nashville back in May, and he really wants to make the agency more efficient. I think, one of the things he did was he stopped all the continuing disability reviews through the end of September, I believe, to take those people and put them on getting rid of or dealing with the backlog and initial and recon. So I think we have a really good commissioner, and I think that he's trying to do the right thing to because he realizes, and I think that one of the things that attorneys we talk about on the listservs is when somebody applies for disability, you're not working, and you maybe have not worked for 6 months or a year. You're looking at up to 2 years to get a decision. So you may have no money coming in for 2 to 3 years. You're at home. You're labeling yourself as disabled, which is a terrible, mental thing to do. I'm sure if your family is upset because there's no income coming in. Your friends may not understand. People in the neighborhood may not understand. It's a really, really tough thing. And I suspect anybody here who's filing for disability knows that it's no picnic to sit at home for 2 years, hoping that Social Security will, see it your way. And then, you're unlucky enough to get a judge with, a 15% approval rate, or you have a judge who gives you, 15 minutes to present your case, you and your attorney, you may not win. So it's a really, really tough thing to do in many, many levels. So I think that, Commissioner O'Malley is aware of the importance that Social Security treat people with dignity, give them a fair hearing, and give them a fast decision. Because if they're going to turn you down, it's much better to find out in 8 months or a year. Maybe you try to go back to work. And again, unsuccessful work attempts, if people have, multiple attempts to go back to work, that becomes evidence. But, these 2.5 year waits are just really, really unpleasant. So, and like you said the adjudicator said you're turning 60. And again, that's a grid rule issue. That's a transferability of skills issue. So it's good that he noted it. And sometimes they got a million files, and I don't know on their system whether it flags somebody for being 60 or not. But I'm glad he noticed it. Okay, Dee Dee, another regular. Good evening, Sir Ginsberg. Hello, Madam Partlow. I assume you're a female. I don't know. I had your CE today. Lasted all 7 minutes. I couldn't believe how bad off I was. He was marking the lowest functioning possible. Of course, is that good? Yes, that's great. That would be really helpful. That means the CE doctor, which, is a big part of your file. It doesn't mean you're going to win, but, it certainly helps when the CE doctor checks off, that you have significant problems because, that is Social Security's creating evidence. That is all obviously great news, and it will really help your case. Doesn't guarantee anything, but it certainly helps your case. That's really good news. Trish, hello from Tennessee. Hello, Trish. Hello. Donna, hello from another regular. Hello from Chicago. How are you? Johnny Doster, I have cubital tunnel syndrome. Can you get disability? I've said this before, Johnny. You don't win based on a diagnosis. And cubital tunnel, obviously limits how you can use your hands. The question is, does it eliminate, and it also depends to some degree on how old you are. If you're 60 years old, and you could argue the grid rule that you cannot lift, 20 pounds on occasion because you're a cubital tunnel, then that might be enough. If you're 45 years old, are there jobs that you can do with minimal use of your hands? Probably so. So I think this is going to really depend on the severity of the cubital tunnel, whether it can be treated in any way, shape, or form. Has it lasted a year? And again, how does it affect your lifting and carrying? And in turn, do you meet the grid rule because of your age? So that's how I would answer that. You're in reconsideration stage, TLJ. I don't know what. Let me go back and see if I can find where TLJ. Not sure where you had a previous question, TLJ, but reconsideration is generally speaking a rubber stamp. Statistically, at initial, about a third of claims, 35%, according to the latest waterfall chart. And you can go to my blog at for Social Security Disability, I'm sorry, ssdanswers.com. There's a link to the blog there. I have a copy of the waterfall chart, which shows the approval rates. They call it that because it looks like a pyramid. The approval rates for every stage at initial, it's about 35%. Recon, it says about 17, 18%. I think it's probably closer to 15%. Hearing is 48 or 49%. So, at recon, it's a pretty low chance of being approved. Now, I've had some approved at recon, but it is not a great chance. Sheila, nice that we talked earlier this week, I think. Nice to see you here. Thank you for tuning in. I appreciate it very much. I hope you're doing well, and you'll be hearing from us obviously very soon. Raymond the fan, AFOL and gamer. What is AFOL? I don't know what that means, but thanks for the useful info. This has, why would an ALJ send a decision back to a writer for decision? Very good question. The reason for that would be that the writer is not in the courtroom or in the hearing office or online when your hearing is being held. And so the judge, makes his notes or her notes, sends it to the writer with instructions. Sometimes they're kind of cryptic. The writer listens to the recording, looks at the evidence, and based on the judge's notes, will issue a written decision. The judge gets it back. And if the judge feels like the writer did not accurately describe what the judge wanted, it will go back to the writer for revision. Now, according to Spencer Bishens, and again, my interview with him is on my SSD radio, he said sometimes writers will actually argue with the judge. They'll say this case really should be approved. And so you may have a situation where a decision writer, puts into writing something that might, create grounds for appeal because he disagrees with what the judge is doing, or he just misunderstood what the judge wanted. Any number of reasons. So, but that's why. It's because it does not meet the judge's vision as to what the decision needs to be. Back in the day, years and years ago, after a decision, the judge would have the attorney write the decision. And obviously this would be favorable decisions. And in fact, I will tell you that in courts generally, state court and federal court, the attorney who files a motion will draft the order. I did bankruptcy work for years and years. So if I filed a motion, let's say, to redeem a car, or to, in a Chapter 13, what they call complaint for turnover. If I filed a motion for, whatever, to release tax return funds would be an example, and I won, or the trustee or the opposing party didn't contest it, I would actually draft the order up. That's the natural way things happen in courts. State court, same way. You present a motion, you have a case, that many times the judge wants you to do it. And it used to be that way in Social Security. They got rid of that. So it takes a lot longer. I remember one time years ago, I had a judge who said, well, I'm going to approve it, write the decision, here's the template. I'd never had it happen before. And so it was actually kind of interesting to do it, but they don't do that anymore. So they have these decision writers do it. Bugs Morand, is after winning your case, is it best to avoid working at all? I would say, as a generally speaking, yes, in the sense that it reduces the risk of a CDR. At the same time, Social Security has a lot of incentives: the trial work period, the ticket to work, which I don't really know much about, the working below SGA, and they do encourage people to go back to work. And I think that for your own mental health and your finances, it can be a good thing. So if you asked me this 15 years ago, I would say it's best not to work. Don't rock the boat. Now, I'm not so sure I would say that. I think that if you can work part-time, it will benefit you both, mentally, emotionally, as well as financially. So I don't see it as a real problem anymore. That's my take. Crystal, can you be approved before going to or getting a hearing date? Yes, you can. If you're going to get approved at the state agency level, it will be while your case is at initial or recon. If you have requested a hearing, it used to be we could write an on-the-record decision, get it to the chief judge or the hearing office, the head of the hearing office, and we might get these decisions really early. That has not happened in years. I don't think that they don't read them. So at this point, the case has to be assigned to a judge, and the judge has to have time to review the record. So in my experience, judges are not looking at the case until a week or two before the hearing. So I try to get my on the record, or not even on the record, a pre-hearing brief / on the record in, a week, 3 or 4 days ahead of time. That's when the judge is looking at it. So yes, it is possible to get it on the record or approval at any stage, at any point, but there's got to be somebody looking at it. And, as far as the judge is concerned, it's going to not be until that judge really has a chance to review the file. But I think if you get it in early in terms of a brief, that's a good thing. Adam Carr, you answered this for me, but I left the room when you gave me the answer. I want SSI and SSDI, good. Approved April 23rd, 24. How long should I wait for the back pay? I'm owed 7 years of back pay. Well, what they got to do first is, if you've got SSI and SSDI, for the SSI part, the SSI people have to do what they call a PERC, P-E-R-C interview, or an income and resource interview to make sure that you're eligible for SSI, because it is a means-tested program with assets and income. So that can hold things up, and that can delay it by several months. I've got one that's been delayed several months. So that's one thing that's going on. As far as the SSDI part, they want to look to see, have you had any earnings after onset? And if you have had earnings, are they at the SGA level? So that can delay it a little bit as well. In general, when you get a decision, if it's an SSDI only, you'll see your money in about 30 days, 20 to 30 days. If it's an SSI, SSDI case or a concurrent case, it can be 2 to 3 months. Now you won and you made your decision in April, so we're now in late August. I think what I would do, given that this amount of time has passed, there's something going on here and you need to find out what it is. I have one case that's been sitting there for like 5 years because my client had a workers' comp case and has never provided Social Security with the workers' comp stipulation, because you have to have some language in that stipulation to show that your lump sum is being paid over your expected lifespan. She won't provide it to him, and I've called her, emailed her. I can't get her to do it. So her money's being held up. I'm not getting paid. Makes no sense to me, but she won't do it. So that can be an issue. So I think that if there is a problem, you need to find out what it is. This is where your attorney can be helpful to get on the phone, call the payment center. What's the holdup? If they don't tell you, this is where you might reach out to your congressperson, your U.S. representative, and see whether they can find out what the holdup is. Nate, the DDS examiner asked about my follow with a specialist. I don't know if that means appointment. They scheduled me for another C exam. I had mental and physical during initial. I'm doing intensive mental health treatment 5 days a week. I think that it's not unusual. I wouldn't say it's common, but it's not that unusual for the recon adjudicator to also send you out for a consultative evaluation. It does happen. It's not that common, but it does happen. I've seen cases where there have been 3 and 4 and 5 consultative evaluations. And generally, if you've got a serious problem and you've got ongoing treatment, this could be a good thing for your case, because the original CE doctor might not have been aware that you're doing intensive treatment 5 days a week. I would certainly say if you can get the CE doctor, the new CE doctor, copies of your records or some sort of a summary, that would be helpful. But that's probably a good sign in your situation. Rock, how long does an average hearing with a judge last? About 45 minutes, maybe an hour, but usually about 45 minutes. They're pretty quick. And that's, by the way, why I always tell you there are certain questions you're going to get asked. So think about those, have your attorney go over this with you ahead of time. Questions like, about your past work and what you did, and questions about your sitting, standing, walking, kneeling, stooping, all that kind of stuff. and be able to say what's wrong with you. I like to do a pre-hearing brief where I put all that stuff in there. It speeds it along. The judge will still ask you, but it just moves it along a little bit faster because you want to spend most of your time talking about your ailments and why they prevent you from working. Remember, the main issue in a disability case is whether you have capacity to be a reliable employee. Everything else doesn't really matter. That's the main thing. So if you're, in your hearing, you want to focus on those things that prevent you from working in a simple entry-level job. You don't want to focus on just your diagnosis or what happened to you 30 years ago or you fell out of a truck as a teenager. You want to talk about, as of your onset date, why, or maybe 6 months before, why you're not able to work. And that's what an attorney will do for you, is to really kind of help you hone in on the most important things, put some of it out there in writing so that the time you have with the judge is really, really well spent. Nate, is it good they're asking for another C exam? 2 case managers, mental health, physical impairments, recon treatment. Yeah, I guess I mentioned before, I think it is good in your situation because I think it does show that, there's somebody is saying, well, maybe we need to see another look here. All right, Garrett is here tonight, and as always, he will put up here that if you'd like a case evaluation, this is where you would go. We use this, and by the way, if you're not familiar with what Bitly is, it is a URL shortener. So in other words, if you ever see a Bitly link, there's a bunch of these companies that do this. It's basically, it's redirecting a long URL into something very short. So we took the case evaluation URL, which is on the website, and we put it into Bitly and got a custom name called Contact Jonathan 3 with capital C, capital J. So when you click on that or you go there, it will redirect to a page on my website where you can ask for a case evaluation. But by doing the Bitly, we can track that it's coming from the live stream. So that's why we use that. So if you are interested in a case evaluation, I would really appreciate if you'd use that link that tells us where it's coming from. I think Main Event was answering a question about whether you can get approved early, and Crystal or Main Event says yes, you can be approved. And again, my experience has been that the judge is going to look at it, a couple of weeks before a hearing, start to do the initial review, and if there's either the medical is just glaringly obvious or there's a good pre-hearing brief in there at that point, that could improve your chances. Garrett tells everybody, have questions about Social Security, put them in chat. Garrett is a practice management consultant that works with me. We've been working together for many years. And so he is here usually every Wednesday to remind people to put their questions in the chat and to how to ask for a case evaluation, which we appreciate that, Garrett. Thank you. And people will start telling hello to Garrett because they always do, which is nice. Okay. Freedom 64. It took me 3 years to get approved. I was determined to fight for it. I had to sell almost everything. I'm sorry to hear that. What's sad for being turned down twice, the judge only took 15 minutes for me to be winning. Yeah, that's not that unusual. I mean, I think that, most every case that I try has been turned down twice. And you wonder why Social Security has such a hard time, finding people disabled when a judge can look at it in 5 minutes or 10 minutes. Look, when I look at the leads that come in my office, every day, these leads are, I can look at it and usually tell pretty quickly, does this person have a good chance? Are they like the woman who was here before, 56 years old, failed back syndrome, spinal cord stimulator on long-term pain management? That's a recipe for a win. I can just tell you, I've done this for 30 years. That's a recipe for a win. On the other hand, a 23-year-old with mild depression, it's probably not going to win. It's just not, at 23, the level of evidence you've got to have is so high that, unless you are really non-functional at all, you're probably not going to win. The tougher cases are the people who are 47, 45 with, bad herniated disc, but maybe not a nerve root issue, or maybe some bulging discs, things like that. Or the person who's got cubital tunnel, where you have to prove they can't do anything at all, and realize that Social Security is under a lot of pressure from Congress to not deplete the trust fund. So they know that anybody who gets approved, in their 30s or 40s is going to be, on this trust fund draining that trust fund for the next 15, 20, 30 years. They make it really, really hard. So, I would ask, adjudicators certainly know the cases that are clear winners, just like judges do and just like attorneys do. Why don't they just approve those? Again, it would make my life harder, but, it would make a lot of people's life a lot easier. So I would rather see that going. So I don't get it. I don't get it. TLJ, 1972. I'm in reconsideration stage of a TBI or traumatic brain injury, 7 skull fractures, frontal lobe, brain damage, executive function disability, multiple herniations, I guess, nerve root compression, gabapentin, which is gabapentin is like a nerve pain medication that is that's also called Neurontin, by the way. Gabapentin, Neurontin, same thing. Functional capacity test showing you're limited to sedentary. I would say first, a traumatic brain injury may or may not be an exertional problem. And what I mean by exertional is, does it limit your physical capacity? Maybe the herniations and other stuff do. So if you're over 50, you want to look at the grid rules, and go to my website, gridrules.net. I will show you that. If you probably already know that, but I will show it to you anyway. This is gridrules.net, and you can see that, if you go to the sedentary tab, that means when your maximum capacity for work is sedentary. Generally speaking, it's hard to win, with sedentary unless you've got really significant problems. You're 55 plus, it's going to be easier, but at 50, you have to have really no transferable skills at all, but limited to sedentary. And again, if you can do sedentary work, you're not disabled. So sedentary work is sit-down work. But if you can do more than sedentary, you're not going to be disabled. Whereas if you look at the light table, even if you can do light work, you are going to be found disabled. And there's where people over 55 win a lot of cases. In particular, I win a lot with 202.06, which basically says that you are 55 plus, again, like the woman who had asked about before, a high school grad or more, most people are, does not provide for direct entry into skilled work and no transferable skills. And again, if you've got significant pain or you got medication side effects, that's going to eliminate that transferability of skills, win a lot of cases on 202.06. So this person here, I don't know how old you are. If you're born in 1972, that would make you, I think, 52 years old, if my math is correct. So, if you're limited to sedentary, like you say here, then, I would think that, the grid rule might very well apply here. So if you're a high school grad or more, no transferable skills, that's 55 plus. Let's go over here. So if you're 201.12 or 201.14, you're limited to sedentary, high school grad or more, no skilled work, no transferable skills or unskilled work, then you could win under the grids at 201.12 or 201.14. And the TBI is going to eliminate transferability of skills, because if you've got problems with executive function, with remembering, things like that, there's not going to be any transferability of skills. So, based on what I'm supposing, based on your screen name, 1972, I think that, the grid rules would be something I would definitely look at the sedentary grid. Vincent, hello, Vincent. How are you doing today? You're doing well. All right, so TLJ, last 15 years work history, truck driver, medium duty labor, and now we realize they only look at the last 5 years. So, being a truck driver is not going to generate a lot of any transferability of skills, to my knowledge, because I think that as a truck driver, you're driving a truck. And the skills you need to do that, I don't know how well they transfer. I guess you could maybe they transfer to being a Uber driver or something like that. Although it's very different, driving a commercial truck. Maybe there's some sort of local delivery, but I don't know that there's a lot of transferability of skills outside of truck driving. And again, if you can't do that because of the problems with closed head injury, traumatic brain injury, then I think that you've got a pretty good argument there. All right, Garrett is saying hello to Christina. and you're 51 years old. Okay, so again, 51, 52. I think that this grid rule at 201.12 or 201.14 very possibly applies, and that's what I would certainly make an argument in a disability claim that 201.12 or 201.14 apply. You can also argue functional capacity and realize if you're arguing the grids or you're arguing listings, you can argue the listings, and the alternative argue the grid. You can argue functional capacity. So you don't have to limit yourself. You can't say, you don't have to say, well, I'm arguing the grids, therefore, I'm putting all my eggs in that one basket. No, it doesn't work that way. You can argue all three. And I've had judges, in fact, a lot of decisions, what the judges do, and I think they do this to protect themselves, they will say the person's capacity to work, there's no capacity to work, but even if there was, the grid rule applies. So they kind of hedge their bets on that regard. So I think it's very common to do it that way. And Raymond, the fan, says, I definitely recommend contacting a senator or representative to have them mark the case as congressional interest to help me get updates weekly. Yeah, absolutely. I think that, I remember Greg Brinkley, he was on a few weeks ago. He told us that, if your congressperson reaches out on your behalf, that goes to the front of the line, and the hearing office manager or the DDS office manager knows that there is a congressional inquiry. In fact, back in the day when we had paper files, there'd be a big red piece of paper on top of the folder, congressional inquiry. So, not everybody uses it, but I think it's a great thing to use. Now, I wouldn't do it, 4 months after you file your application or your recon. You want to wait 6-7 months because that's just how long it takes. But once you get beyond 6 or 7 months, I think that would be appropriate to reach out to your representative, or if you have a really dire need, you are about to lose your home, you're about to be homeless, reach out to your representative. Absolutely. Okay. PMFG. Does overpayment happen with SSDI or is it only directed to SSI? No, it definitely happens with SSDI. And the reason it can happen would be that you use up your trial work period months and you start going over SGA, 2024, 1550 a month. So let's say that you've used up your trial work periods, and again, it's 9 trial work periods in any 5-year period of time. So let's say that in year 4, you don't even realize that you've used them up, and now you are, working and you're kind of hovering around that SGA amount, that 1550. You have a couple months where you get a bonus. Now you're over it. Then you're below it. Then you're over it and you're below it. Well, Social Security may not figure out that you are over SGA for 2, 3, 4 years. And in the meantime, you've got, X number of months where you're over SGA and you're overpaid. And, if your benefit amount is $2,000 a month and you've got, 10 or 20 of these overpayment months, now we're looking at some real money. So yeah, it's a real problem. So yeah, but it definitely happens in SSDI cases. And you can ask for a waiver of overpayment or a waiver in the amount of money they collect from you, the repayment terms, and they have become a little more reasonable on the repayment terms. You can bankrupt on it, but people that want to litigate it, because the argument in litigation would be in front of a judge, Social Security misled me. I've never seen that work. So I think that generally speaking, the best thing to do if you've got an overpayment is, ask for a waiver. You can appeal it, ask for a waiver. If you can possibly bankrupt on it, or ask for a change in terms. But it's not going to probably be something, if you go to a hearing, you're probably not going to win. Donna says, this week I visited the disability internist doctor, exhibited who was rude behavior. This doctor be reported to inform SSA or wait for the hearing. I get this question sometimes from my clients. You can certainly let the adjudication office know that the doctor was rude. That type of feedback is helpful. Certainly let your attorney know, because I will tell you in the listserv sometimes we will see questions, what do you know about Dr. X? And, if Dr. X is known to be rude or unprepared, that could be probably pardon me, that can be very helpful. So I would certainly say, yeah, let Social Security know, let the adjudicator know, let your attorney know. May not change anything, but we don't need rude doctors out there, certainly. So, why not? Nate is 38, has a mental RFC filled out, of herniated disc and cervical and lumbar, autoimmune, persistent asthma, COPD, severe depression, IOP 5 days a week. You got a chance. You're 38. That's the biggest problem. You're being 38. You've got the RFC, and I will tell you the one area where age does not seem to make as much of a difference is mental health. So if you've got a severe mental health problem that's well documented, you've got support from your doctor, being 38 is not the end of the world. And you've got these other problems as well. So yeah, you got a chance. Is it an uphill battle? It is an uphill battle, but you do have a chance. Raymond. I applied the first time all the way to federal court, got a remand, got approved for remand, now trying to make my onset date, waiting for ALJ decision and prior denial after remand. Yeah, so basically it looks like you appealed an onset date and the case got to federal court, it was sent back. And, I think I've talked about this, that some judges feel like, well, if you went to federal court and the federal court sent it back, they're sending the judge a message, approve the case, do what we want you to do, make the right call. And some of them will do that, or some of them feel like, okay, I'm not going to, argue with the district court. Others are going to say, I don't care what the district court says, I'm going to do what I want to do. We have a judge local here who is, not nobody's favorite. We'll just leave it at that. And I got a remand from federal court on a case with him, and surprisingly, and it was a case that he would never in a million years approve. And he was angry about it. He wrote a 2-page footnote in the decision, never seen this before, basically saying, I disagree with the federal court. I don't think this person's disabled, but they're forcing me to approve it. I'm approving it, but I don't believe a word she's saying. Never seen that happen, but he backed down. So we got our win. But some judges just like, I don't care what the federal court says, I'm going to do what I want to do. And it's unfortunate, but that's the way it goes. Bryn, how long once disability determination has your forms and records about a decision initial? It's going to depend on where you live. There's some DDS offices in Texas where it'll be a year before they even assign an adjudicator. So the case just sits there in limbo for a year. Other places it's 8 or 9 months. I tell people best case for a decision at initial is going to be 8 to 12 months. That's pretty common. It's almost never earlier than that, usually not later than that. So I would assume, my experience, and this is not, written in stone, but my experience is initial applications, start to finish is going to be about 8 months to a year. The recon's about 7 to 9 or 10 months. The hearing's going to be, 5 or 6 months. So, it all adds up to being about 2 years before you get to your hearing. So when I talk to my clients, I'll say something like this. In a best case scenario, we win in 8 or 9 months and you get your money and you move on. If it's turned down and we should still appeal, it's going to be 2.5 years. And that's kind of the general time frame. Okay, GC24 Styles. When you get accepted at vocational rehab, the state is already confirming you're disabled to a degree. I completely agree with you. I think that, anytime another agency finds that you are eligible for a program that is applicable to disabled people, you are been found that. And again, Social Security's policy is we will look at those decisions. We'll look at a VA decision. We'll look at a state decision for Medicaid, but we're not bound by it. So yes, they'll look at it, and some judges will look at it and say, well, they've already found this person meets a listing, for example, or they've made this decision. I'm going to at least look at that, but they're not bound to follow it. But they will typically look at it, and I think it helps. It's certainly useful, just like a handicap driving permit is helpful. It doesn't mean that you are disabled, but it means that some doctor felt like you have enough going on where you need help and you need to be in a closer parking space. And so, doctors aren't going to do that unless they feel there's something there. So yes, but it doesn't, not determinative. John Lee, I received and completed adult form 3378, work history report 3369. My online account says I'm at step 305 in the process. What comes I think you meant step 3. In the process, what comes next? Will they schedule the CE exam and move to step 4? Um, I don't see online accounts. I'm not sure if you mean they're in the 5-step sequential process or just kind of in their own process. Um, I don't think, and I think, my friend Stephanie, when she was on, we both agreed, what you see in your online account, I don't think it means anything. It's just a made up number. How do they know that you're 73% ready? It's impossible to know that. So it's just a way to let people feel like they're working on it, but it doesn't mean anything. So at the end of the day, you submitted some forms, the case is being worked. I come back to initial is going to be, 9 to 12 months, recon 6 to 10 months, request for hearing is going to be, 5 to 6 months. So everything else is, I think, just garbage. Johnny had a hearing in the vocational, so I was disabled, then said I wasn't. Okay. Johnny's the one who had Cubital tunnel, I believe. All right, so realize that at a hearing, what he's talking about here is at an ALJ hearing, the judge will typically have somebody called a vocational expert witness. And this is a person who has knowledge about placing people with medical problems, and expertise and knowledge of the different resources out there, like the Dictionary of Occupational Titles, other vocational Department of Labor publications that show numbers of jobs and requirements for jobs and things like that. And you've never met the vocational witness, their resume will be in the file. And one of the things the judge always asks me as the attorney is, will I agree that the vocational witness, is an acceptable expert witness? I usually do, unless there's a reason not to. And I will tell you that some of my colleagues feel like, every vocational witness is flawed and their testimony is fatally flawed. They will never stipulate to that. And they may cross-examine the VE's qualifications, and they may use that for appeal. Now, again, I want to win early. I don't really need to make law. So, my feeling is the judge is going to typically accept the VE and listen to what the VE says, unless there's something really, really outrageous. And again, a school of thought is challenge the VE's numbers. The DOT was last updated in 35, 40 years ago. The numbers they come up with are just wild estimates based on all these different things, and a lot of it's just math. Let's say that there are 10 DOT codes in a certain Department of Labor publication, and they want to know how many jobs exist for this particular DOT code. They'll divide the total number by 10. Well, that's probably not accurate, but that's what they do. And again, there's enough case law where unless you can show absolutely they're wrong, that judges are allowed to do that. So that, as a background, is the judge will ask questions at the end of the hearing to the vocational witness, after qualifying them. So, Mr. Vocational Witness, I want you to assume there's an individual who's the same age as Mr. Doster, the same age as any claimant, the same education, same work experience. I want you further to assume this individual, because of back issues, cannot climb ladders, ropes, and scaffolds, cannot bend, stoop, kneel, crouch, and crawl, otherwise is limited to light work, can reach overhead with the left dominant extremity on a frequent basis, can frequently handle and finger. And frequently is not the same as constantly, but it's pretty, I'd say a good part of the day. Based on those limitations, can this claimant return to past work? If not, are there other jobs that exist? And based on the DOT and other publications, there are jobs that probably exist. The next question might be, Mr. Vocational Witness, in addition to the limitations in hypothetical number one, let's now assume our person is limited to sedentary work, and this person would be off task for 15% of the day because of pain or medication side effects. There, the answer is going to be there's no jobs. So the judge may ask 5 or 6 hypotheticals, some of which are going to say there are jobs, others which are going to say no jobs. And obviously the judge has got to pick one of those to represent what he or she feels is your residual functional capacity. So the vocational witness is not there to hurt you or help you, just there to answer questions for the judge. And normally, one of the questions the judge asked or two of the questions will get the testimony there's no jobs. The person's off task, or there's, they're going to miss 2 or more days of work a month, or the person, has really severe limitations. But there's going to be maybe 1 or 2 that, that are not restrictive at all and that show jobs. In fact, many judges will take the DDS RFC, I know I'm talking in tongue here, the DDS, Disability Determination Services Residual Functional Capacity Evaluation, and repeat that. And obviously the DDS has already found you able to work with that, but the judge wants to hear it from the VE, and then he may add additional limitations on. So it's not unusual to have 3 or 4 or 5 questions. Some judges will pick a question that has got more restrictive limitations. Others will ask all these questions with restrictive limitations and then deny your case based on the one that had limited restrictions. So it's just, that's why that happens though. Ellie Brown has tuned in. Ellie, we couldn't wait for you, but I'm glad you're here. William Rodriguez, I'm waiting for a recon decision for 7 months. How long does it take in Florida? Florida is backed up. And, I think you're at the point now where it might make sense to reach out to Senator Rubio, or I think it's Senator Scott, or one of your representatives, your federal congresspersons, to ask for a congressional inquiry. 7 months at recon's a long time. So it's not, completely beyond the pale, but it's pretty long. So I think, you should be getting pretty close. Please do a Nebulung Pixie. Please do a video short regarding quality reviews. Thank you for your videos. Quality reviews, by the way, are where Social Security, after a decision, somebody comes in behind and does a review. Just was the decision made properly? And the shorts basically are these 60-second videos on the YouTube channel. So I will tell you that basically quality reviews, we don't really have a lot of control over them. They are done just to make sure that the people at the DDS or even at the ALJ level are doing their job properly. I have a case right now it's clearly the guy's disabled, but we got a favorable decision. But then the appeals council on their own decided to take another look at it. So it's been held up for now 2 months, and my poor client is like emailing me on a regular basis. I understand why, what's going on, and there's nothing that's telling me what's going on. I don't know what they're going to do. If they're going to have another hearing, I mean, we'll win again, but that's what he is. And he's a really nice guy and should be approved. Charlie, if you're watching, I'm talking about you. Kelly says, hello, barrister. That's the term you don't hear very much. Barrister is a term for a lawyer. They're barristers and solicitors in England. I think the barristers are the ones with the white wig. And the powder wig, I'm gonna have to dress up in different kind of clothes. It's kind of cool, but I don't think I would work real well with a white, powdered wig. But maybe they're actually expensive. I understand that to get one of those powdered wigs is like, hundreds of dollars, and the robes and so forth. So I don't know, but I'm not a barrister. I'm just a hard-working attorney here. I've been prescribed a very expensive inhaler for my COPD. If I don't fill the prescription because the cost is high, will a judge use it against you? No. If you don't follow a judge's direction because you can't afford it, that is not used against you. I would, however, let your doctor know the reason you're not filling the prescription is because it is just too expensive for you to do it. Is there something else? But you're not undergoing surgery because you're concerned about it, or because you can't afford it, or not getting an inhaler or some medication because you can't afford it is not held against you. There is specific law on that. William, John is responding to William. I'm in Florida. They denied SSI application in 30 days. Everyone's different. Realize, John, SSI is a little different in that you may not be approved, or you may not be qualified because of non-medical reasons. Maybe there's household income. Maybe, if you're talking about SSDI, you don't have enough credits. I'm assuming it's SSI. But, maybe you have a spouse who earns 50 grand a year. Maybe you have, $50,000 in the stock market. That could disqualify you. So many times a really 30-day, 20-day 10-day denial is going to be because of, in SSI case, because of assets or household earnings. But it could also be because you had a really diligent adjudicator look at it. Karen White, how long can it be after initial denial to start an application? Again, you have 60 days to file an appeal, so I would do that. If you missed it before filing a new application, at least talk to a lawyer about, can I file a late recon appeal and ask for this, initial denial to be reopened for good cause, and that will keep you in your existing case. Otherwise, you can file. Theoretically, you get denied on Tuesday. You could file a new application on Wednesday. Again, it wouldn't make any sense to do that. I think it's better to appeal it. But as soon as you decide you cannot appeal, or your appeal is somehow rejected, then you can file a new application. There is no no reason not to. I will tell you that at the state agency level, 2 hours of tennis, and I played terrible. I was so bad today. I could not hit anything. My forehand was just, I'm a pretty average tennis player, but normally I get the ball back. And I was just, my backhand's better than my forehand. I just could not get my forehand. They were serving my forehand. I was hitting it out. I was just bad. When I was in Charleston, the Olive Palms area, I played on clay, and then I've been playing on hard courts, since I've been back. And of course, clay is a much slower surface. The ball bounces differently, and it's just a slower paced game, different. It's hard in its own way, but just coming back, I cannot get used to the pace, but I was just beyond bad today. So my playing partners were all sort of happy to see me go, as was I. Terrible. Okay. But yeah, you can go ahead and file your initial application right away, Karen. There's no reason not to. But again, before you do that, I would certainly tell you to consider at least the idea of appealing it, if you can possibly do that. Okay. St. Louis, person files for recon. Nothing has changed since their initial claim. The recon go through, there's been treatment since then. Now, recon is to ask them to reevaluate, to take another look at it. Realistically, if there's no change, you're going to get the same decision. But the people at initial and recon are looking at different things than a judge would look at. So, I kind of group initial and recon sort of in one bucket and a judge in another. So being denied at initial and recon doesn't mean anything. A judge is going to look at it completely new. Initial and recon, they're looking for listing level or maybe grid rules. They're not going to be looking at functional capacity so much. At the hearing level, you're going to be looking more at a functional capacity issue. So, it's probably not going to get approved at recon if you're denied at initial, unless something significant has changed. Keisha, my daughter has SSI. She's turning 18. What should you do to reapply again to any attorney? You don't need an attorney. I think that, is she applying for SSD as or she's applying for SSI, I guess, as an adult as opposed to a child. Again, if nothing has really changed, the state, she should get approved, or she's tried to get as an adult, disabled adult child. The standard is always the same, whether you have capacity for work. Now, the difference between a child SSI evaluation and an adult SSI evaluation is the listings in the child case are different because they're not looking at your work. They're looking at things like school or age-appropriate behavior, things like that. But if you got approved, your child got approved at 14 or 15, then, it's certainly a pretty good argument they should be approved at 18 as well. But I don't know you need an attorney. You can certainly talk to an attorney. I will tell you that it's hard to find attorneys who do, child SSI cases or young adult SSI cases because they are hard to win. If you're getting ongoing benefits, it won't be any past due benefits. So how do you pay your attorney? But it might be worth a phone call. But I would probably tell you to go ahead and just apply. But if there are attorneys who do SSI, child SSI, then certainly we're talking to. Dog mom. I've had 4 spinal surgeries, fusions, decompressions. They failed. Nerve root impingements, need surgeries. That came to meet a listing. Possibly you meet a listing. I think that you can certainly argue the listing. You could argue a grid rule if you're over 50. You could argue functional capacity. So I would say if you identify the listing you think you meet, then reference that, and then also saying the alternative, please evaluate my case, evaluate my case as being one where my functional capacity has been so reduced by the nature of my injuries and medication side effects that I would not be reliable in any kind of work, or please look at this under grid rule 202.06 or whatever. But yeah, you can certainly argue you made a listing. And, I don't know if you do it without looking at the record, but 4 surgeries that have failed, a nerve root impingement. It sounds like you got at least a possibility of meeting or equaling a listing. You don't have to always meet it. You could equal one. So if you're, in every listing, there's a functional element to it. So if you've got pretty close to everything in the listing, but missing one small part of it, you could argue that you equal the listing, and that can sometimes get you over the threshold. Okay, Kendra, I'm feeling hopeless with an ALJ that has high denial rate. Case for 3 months now with the AC. They'll send it back to the same ALJ and request the ALJ to be complete. You can ask. They're probably not going to do it. Typically, on the second time around, if you go to another appeals council or the district court, and they send it back a second time, it'll be a separate judge. But if it goes back to the same hearing office, now theoretically you could move. You could also, I think, don't make absolutely certain, but if you had a virtual hearing, you could maybe ask for an in-person hearing. Maybe you get a different judge that way. If you move, you can ask for a different judge if you felt like there was something prejudicial about this judge. But generally speaking, it's going back to the same judge with instructions if you win at the AC or the district court. And realize judges move around. I mean, every year there's new judges. There's judges that have left, retired, transferred. So you never know. I mean, may end up getting lucky. The judge could be sick that day. You just don't know. But you can certainly ask, and you can beg and plead, but asking is probably as good as anything. Isn't it the case, if one files a recon, they can still file a recon if they lose? Reopening gives an additional chance. So if you file a recon, you can file a recon. I don't know if that means. I mean, I think that if you lose at recon, you request a hearing. But yeah, you can keep appealing. If you lose at the hearing, you file a request to the AC. If you lose the AC appeals council, you request district court. You lose at district court, you can ask for circuit court appeal. Yeah, at some point you're not going to get them. Some of these are discretionary, but certainly at recon you have the right to request a hearing. Keisha, I think we've already talked about that one. If you inform your DDS examiner of new treatments, are they obligated to follow up? Generally speaking, yes. I think it's helpful. And what I do is if I have a new doctor, I will provide the DDS adjudicator with the name and address of the doctor, the dates of treatment, and a request that they get these records, or I'll go into my client's patient portal, I'll download the records, and I'll send them in. So yeah, I think the more help you can give give the adjudicator, the better, and the more pushy you can be in terms of getting these medical records, the better there. I think St. Louis Graham meant reopen. If you file a recon, again, as far as reopening a recon, I guess it could be done. You're just going to request a hearing. There's no reason to, you have 60 days. So, the question is if you file a request for review or reconsideration of the reconsideration or whatever, it's probably not going to happen. Just request a hearing. Let's see what we got here. Kendra, is there a way to contact the AC to get updates on my case? You can contact them. I don't know that they're going to really give you much of anything. I've never really had any way to find out what's going on at the AC, which is until they actually issue their written decision. But you can call. I think if you call the AC, and you give your information, they will tell you kind of what's going on. But I don't know. I really have never called the AC on that, but I think that's what happens. It is very important to make sure all your doctors are documenting your issues and your notes. Absolutely. I think GC 24 is right. Look at your portals, look at what the doctor is saying. If they're not mentioning something, or if they're just repeating the same thing over and over, write a letter. That gets into your portal, upload it, and it goes into your record, and ask the doctor. Say, look, doc, this is really important in my disability case that you're accurate and you're up to date as far as what's going on. So yeah, absolutely. Kendra, contact my state rep. They only cannot do anything once the case made an AC. State representative, you mean your U.S. congressperson? Again, I always go with senators. I just go with U.S. senators. I've not heard that, but it is certainly possible that the AC is not going to listen to. Although I think that any Social Security office that gets a query from a U.S. senator, they're going to respond to it. So I don't necessarily buy that. I could be wrong. Could be wrong. The whole system is a scam. They treat citizens like crap. But you all allowed this. I don't think it's a scam. I just think that it is a huge bureaucratic, monstrosity. I think that there's a lot of political pressure in Congress to limit the benefits paid out. I think there's a narrative in Congress, false as it may be, that everybody in Social Security is, faking it or exaggerating their symptoms. Social Security in Congress's eyes, the most important thing they can protect is the retirement Social Security. Disability is not as important to them. They realize that there are people who are disabled, but there is a general sense that the program has expanded too far. So, I think that, some people believe Social Security in general is a big Ponzi scheme. It's the most popular federal program out there, so I don't think that's the case. It's supposed to be a safety net. It was never intended to be your sole source of retirement or function or income, but it is. So it's just a system that's evolved over time to be very, very, difficult to navigate. It's very clunky, takes a long time. It is what it is. Raymond says the AC is slower than a tortoise, and most of them they deny review. I called them and asked for fast track. No bearing on the decision to deny review, but I got it remanded. The AC is, they got judges up there. I don't know much about how the AC works, but my sense is that the judges there, have a certain thing they're looking for to remand a case, and they look at the evidence, they look at the brief, and they make their decision. It's not a high percentage of people that are remanded, which means it goes back to the judge for their hearing, or a high percentage of people who get approved. There's certainly a high percentage of people get denied, but it is what it is. I mean, it's the AC is it's kind of like recon, in my opinion. It's a way to delay the process. The remand only happens at ALJ. There's something wrong. Errors of analysis. I will go with that. ALJ denies when the VE says no jobs in the economy. ALJ so well again. And I will tell you, I've had people had a case where my client insisted the VE was asked only one question. I got the hearing tape, listened to it, or the hearing recording. The judge asked the VE 5 questions. That's, I'm sure, what happened. That the VE was asked 4 or 5 or 6 hypotheticals. One of them was no jobs, but maybe 3 of them were jobs, and that's more likely than not what happened. Yes, evidence is key. Gracie, 15-year-old daughter is receiving auxiliary benefits based on SSDI. He's been battling anxiety and depression. Could he get DAC if not well by 18? Yes. DAC is disabled adult child. If you have a parent, or grandparent, depending on who's your guardian, who's on Social Security, retirement, or disability, and you became disabled prior to age 18, you can qualify on that person's earnings record. Now, it sounds like she was getting auxiliary benefits because she was a minor child and you got on disability. So she was never adjudicated to be disabled. But, if you wanted to file a disabled adult child claim, she would have to qualify under her own merit, and then her payment would be based on your earnings record. This is all your fault. I don't know if I agree with that. Again, I think Heisenberg is talking about us as a society that, that we elect Congress people, senators, representatives who treat Social Security like, it's a, reluctantly they're going to give it out. Um, you know, but I think that for a lot of people, honestly, Social Security is not their prime issue. So, you may have a representative that does a lot of things that you like, or, they got in for some other reason because they had a lot of money, and they can afford to spend a lot of money on TV ads. And, they're concerned about the fate of a disabled person, in some small town is just doesn't exist. Unfortunately, that's just the case. Okay, on step three, recon, and again, step threes, I don't know what steps mean. Inform DDS of new treatments. I think we've answered that. Yes, you would ask them to follow up. They should. It's been remanded 2 times, third time seeing a judge. I think at some point the judge will get the message, but the judges are independent. They can do what they want. So if the judge keeps denying you, hopefully got a different judge. Raymond, adult fan of Lego. Okay. Well, Legos are there's actually some really interesting Lego sets, like a Saturn V Lego set, and, airplanes and so forth. So, I went down one time. I was in Disney World, and there's a huge Lego exhibit there. Just I don't know, thousands and thousands of Lego pieces and all kind of interesting constructions. So it is a something that is probably good for the brain in terms of spatial relations and put the things together. So yeah, there's nothing wrong with being an adult fan of Lego. Okay. So 6 years of waiting multiple appeals. Finally captured extreme pain diagnostically during sleep, limb movement, 10 times higher than it should have been. Yeah, there are just certain times where you have a judge who doesn't want to approve, or you have a condition that is really hard to document. It's frustrating. It's just really frustrating when I get an unfavorable decision for somebody who clearly is disabled. It's really frustrating and makes you angry. But, you got to just follow this. It's a system. It's a system. Okay, Jordan. Hello from Alabama. Received disability hearing 5 years ago. You've videos prepared me, 26 years old, with cerebral palsy and lupus. Well, I'm glad, Jordan, that the videos were helpful. Obviously, cerebral palsy is a very significant problem that's going to limit you. It's unusual to win at 26. Obviously, the medical is really strong. Got to fly to Mexico, cross the border, all is free. I don't know if I do that, but okay. Jordan L is happy for you. If the pain wakes you at night, ask for a sleep study if you don't think it can backfire on you. Again, sleep studies are going to just eliminate, many transferable skills. It shows you've got non-restorative sleep, but you're not going to win on that alone. But certainly if you can get one, why not? Jen is my paralegal. Hello, Jen. How are you doing? Deb, Lisa, how old are you? One of the biggest challenges to get approved under 50 with a combination of mental and physical impairments and mental health and physical issues, intensive care management services. I think the biggest challenge is proving you cannot do any kind of work at all. At 50 or 55, you still have you can still win if you have some capacity, but at under 50, you have to show you can't do anything at all. And again, the level of evidence, the further you are from 50, the more evidence you need. It's just because judges are just under pressure not to approve. 44 is an old picture. Okay. Shannon had a telephone hearing on Monday. Thinking, well, good. That's always a good sign. Although, I will tell you that, I know when people take the bar exam, they think they did well, that's usually a sign of real danger. So you kind of want to walk out of certain exams thinking, I really screwed this up, and you probably did okay. But hopefully Shannon won. TN says, do you know how long the federal appeals process works in Michigan? Filed on December 23rd, December 2023. I don't. I suspect, like a lot of places, it could be up to a year to get a decision from the district court. It really depends, with district court cases, there'll be oral arguments typically, so you need to find out where you're at on that process. If the argument's been made, is it now in the hands of a judge? That'll probably give you a better idea of how long it's going to take. MAME, I've been diagnosed with retinitis pigmentosa. I'm legally blind while I get disability. You're going to probably need to meet a listing. So I would look at listings. Let's take a look at the listings. I would look at listing 202, 2.02, 2.03, and 2.04. Let's go ahead and take a look at that. Okay, so here are the listings. I'll make this a little bit bigger. So if you see 202.02, 202.03, and 202.04, those are the listings that really talk about visual impairment. And I think you need to look at those, print them out, take them to your ophthalmologist, ask, do I meet or equal one of these listings? That will really tell you whether they have a good chance at winning. Theoretically, vision problems can win under a functional capacity evaluation. I've done it a couple of times, but usually for vision issues, it's a listing situation. If it's not listing, then you need to have something else, in addition to the vision issues. Madeline. Madeline is a legal assistant in my office. Hello, Madeline. I hope you are doing well. And, I got Madeline, Jen, and Garrett on the call. Deb Lindley. Lisa, your age could definitely be playing a part in your analysis. What state are you in? Okay. Jack Sizz, S-Y-C-Z. I hope I'm pronouncing that correctly. Are there circumstances where in mental health disorders, inability to work with people, especially the public and manage the circumstances, would be favorable? What kind of evidence? So yeah, I think if you can show that you are not able to work around co-workers, supervisors, the general public, that can be helpful. It can eliminate jobs, obviously retail jobs, dealing with the public. In a mental health case, it could be because of severe anxiety, PTSD. I've had a number of cases where people have PTSD because of a male figure or a female figure, or a person with facial hair. It could be. So yeah, I think that's going to eliminate jobs. The question is, will it eliminate every single job? Will a judge, and we haven't really seen this much, will a judge say, well, if you have the ability to work at home, you're not going to see your coworkers, and certainly, they're going to also assume that dealing with a manager is something everybody's got to do. So, yeah, I think it's a factor. Is it going to control your case? Probably not, but I think it is definitely a factor. All right. Heisenberg is a bit of a cynic here, but I get it. That you don't have any choice to pay taxes. Heisenberg says, they're going to, that's something you don't get to choose at this point to contribute to Social Security. Again, I think Congress people, politicians take the retirement Social Security very, very seriously because retired people vote. And disability, it's not as big of a deal because disabled people don't really make up a voting bloc. Just the truth. I got approved, says Raymond, in August of 23. They awarded one SSI, got a back pay in October. Okay. You can only get SSI as of date of approval. So it looks like you got your SSI approval 1 month, and then the rest of it's offset by your SSDI is what I'm thinking is going on here. Okay, and that happens a lot, by the way. The SSI you get during some of the waiting period, then once SSDI kicks in, it offsets it. Okay. Okay. Heisenberg, I see a number of comments here, and I'm not disagreeing with you that, you know, it's not inappropriate to be cynical about the Social Security system and about our elected representatives. You just can't change it. I mean, it's just what it is. And so, you know, there's not going to be a popular movement of people to say to Congress, you know, you need to reform Social Security. They call it the third rail of politics for that very reason. So it's going to be tweaked, but it's not going to be changed. All right. If people fight, they can win. Yeah, you have to be a nudge. You got to be a pain in the A. You got to just keep appealing. You just can't. If you look at my website, don't take no for an answer. That's kind of what you got to do. Canine Companion says, I had a court date, but was approved. Back pay cut a week ago. Great. And it does happen. Not very frequently, it does happen. Heisenberg wants to overthrow the corrupt government. Again, I think we're a long way from that. Okay. Thanks for your time. Sorry to repeat. Your knowledge and time is invaluable. Thank you very much. I appreciate that. Good question, Kendra. Does the AC have the ability to approve without sending back to the LJ? Yes, they do. It does not happen very frequently, but it does happen. So it's like 1% of cases, they'll actually just go ahead and award benefits because these are judges, so they can do that. All right, Social Security, that's Garrett saying, here's your case evaluation. Let me put up here again another link to the review page, because again, the reviews, I always get a few reviews every week, and that's very helpful to my Google rankings. Crystal says, thank you, main event. Brianna says, I've already had my ALJ hearing in March, not heard anything. Laura says, maybe you should ask for another judge. What do you recommend? What I would do, if you've had a hearing in March and a hearing, I would probably, if I was your attorney, I would write to the regional chief judge and say, we had a hearing in March, we haven't gotten a decision, this is causing hardship, and please ask the judge to expedite the decision. Raymond the Fan is responding to Heisenberg. Yes, that's why it's important to vote. And look, if you have an opportunity to go to a town hall, to meet your congressperson, write a letter, tell them how important Social Security is, and that, this needs to be changed and what you want changed about it. Example would be the treating source rule. There used to be a rule up to a few years ago where if you had a doctor who'd been seeing you for, regular basis, several times a year, that doctor's opinion would be given controlling weight, whereas a non-examining doctor or consultative doctor, that would be given less weight. Social Security changed and got rid of the treating source rule. So now, technically, a judge can deny you based on a consultative evaluation or based on a non-examining physician report. That is ridiculous. If you talk to your congressperson and say, look, Social Security needs to reinstate the treating source rule. They need to give controlling weight to a doctor I've seen. This is not fair. So I think, the more you know about the way Social Security works, there needs to be, enough money allocated so they can get these cases evaluated in 3 or 4 months. So we don't have to wait 2 years for a hearing. There should be, regulation or law that a hearing has to be given within a year. Otherwise, you automatically get benefits. Is it going to happen? Probably not. But, that's the sort of thing you can ask your congressperson, because as Heisenberg does point out, others have pointed out, people in Congress, they have gold-plated insurance. They're getting a lot of money. They're writing, many of them become lobbyists after they get out of Congress, and they don't live the life you do. And do they really care? It's your own. I don't know. Johnny, would you ever take an Alabama client? You've been to some judges in the Alabama Social Security office in Montgomery. I have been. It's really not against. I have appeared before judges. I take cases all over the country because it's all done by phone or video. So now, if you've had a hearing, you've had an attorney, I don't like to get involved in cases where somebody has as an attorney. I don't think it's really appropriate for me to take over somebody else's case. I had people ask me to look at unfavorable decisions, and a couple of them I've taken those cases, and we'll take them on, and then get the appeal filed. But if you've had an attorney, and you've got somebody, I usually say stick with the person you've got. But I do take cases in Alabama, any any state. Because again, the hearings are done just like I'm appearing by video here. My hearings, I appear by video or by phone. I literally have hearings. I have a telephone hearing where I'm dressed in my t-shirt and shorts, trying my case because it's done over the phone. Nathan, come on, Nathan. I mean, I'll be a smart aleck and say, what are the vocational implications of that? But assuming you're not being facetious, I would assume you're going to be in a certain amount of pain or you may have restroom issues. But beyond that, I think you're pulling my leg. That's what I think. Deb Lindley is responding to Jack about the mental health case. Yes, this is like in terms of not being able to deal with coworkers or supervisors or the public. The more documents, the better. Hey, Rodney, I know I owe you you want to listen to the hearing thing, or the actual recording of the hearing. You sent me the disc, which I've got right here. I was out of town. I've just been really busy. I'll try to get to that next couple of days and get back with you. Okay, what does modified sedentary work mean? Well, sedentary work by definition is standing and walking no more than 2 hours a day, lifting 5 pounds frequently, 10 pounds on occasion. Modified would be something less than that you could do that, but let's say, you can stand and walk for 2 hours, but no climbing ladders, ropes, and scaffolds, no kneeling, crouching, crawling, or stooping. You can lift 5 pounds frequently, but you need both hands. That's a modification of the sedentary RFC. So it basically means that you're able to do sedentary, but with restrictions. So it's got to be a special kind of sedentary, not every sedentary job, but only maybe 30% of sedentary jobs would be available given your specific needs. Maybe you need special shoes, or maybe you need to alternate sitting and standing. You can stand for a total of 2 hours in a day, but it's got to be no more than 10 or 15 minutes at a time. That would be a modified sedentary. Okay, again, and I realize that we are, we've got some folks in here who are very cynical about the system, and I don't disagree that the system has some faults, and that Congress is not the best steward of our money. I think we can all agree on that. The purpose of this live stream is to help answer questions about disability. You're talking about policy questions where, again, there is certainly reasonable debate. I don't disagree with some of that, but we're not going to solve that problem here. But I would tell you, if you see a problem, reach out to your congressperson and tell them your opinion. Tell them your opinion. Nathan, you're the one with the broken penis. Hello. And hope that you got it fixed. Mark Turner. Thought for sure I won. The ALJ had me fooled. Definitely fight it, worked hard. I'll be trying. Yeah, sometimes you have an ALJ is really, really nice. The ALJ is like, everything looks like it's going great, and then boom, you get a denial. I've had it happen the other way. The ALJ is nasty and mean, cynical, sarcastic, and you get an approval. But yeah, some ALJs are just nice people, but they don't approve cases. Garrett reminds everybody, do not forget to like the video and subscribe. It helps others see the video. Yes, it does. Thank you, Garrett, for that. Appreciate it. And let me go ahead and put the case evaluation. Okay. Okay. All right, now Heisenberg thinks that retirement should be 50 years old. Well, I don't think maybe in France they got it. Mame is 52 years old, diagnosed. Oh, we've already talked about that. R. Robinson, Social Security disability videos. I'm 100% permanent and total for the military. Did my hearing, and the 14th judge was unable to do my military job description. It depends on how old you are, but the VA determination is not binding on Social Security, certainly. but it helps. And being 100% will get you a faster hearing, and it does mean something to Social Security. So if you're unable to do your past work, you might grid out. That could be a grid thing. Okay, I recently had to go on short-term disability due to my RA being so bad I could not work from home anymore. Applied for SSDI recently. RA, RA rheumatoid arthritis is a very serious form of inflammatory arthritis, unlike osteoarthritis, which everybody gets as we get older. Rheumatoid, you're going to have the redness and the swelling of the joints. And if it's severe, it can really limit your functioning, your mobility. So you don't want to know a diagnosis, but rheumatoid arthritis is a diagnosis which often produces very serious functional limitations. And that's really what you need to look for. So if it does in your case, it sounds like you can't work from home anymore, then it very well could be, but that's what you want to really focus on. But, is it severe? Is it significant? Yes. Rheumatoid arthritis cases often get approved, but, it just depends on how severe the case is. Keith is 51, mental health, severe depression, anxiety, and so forth. Issues holding down jobs as you get older. I will tell you this. I've talked about this before. That mental health cases are always tough because they're going to have to rely on what your psychiatrists and psychologists say. My standard, what I think takes to win would be, and not in order, have you had an inpatient hospitalization? That's an indicia of severity. Have there been suicide attempts? Other indicia of severity. Have you had multiple failed medication trials where the judge is trying you on one medication after the other, increasing the dosages? Nothing seems to work. Do you have long-standing treatment with a psychiatrist and psychologist, not just psychologist, but a psychiatrist as well, and you're not getting any better? Have you, been through all these different programs? Have you tried to work? It sounds like you have. That's kind of what you got to show. But, if you simply go in and you've gone to a social worker, for 3 months, you're not going to win. So it's really uphill, but you've got to have real indicia of severity, I think, to have a good chance at winning. Fingerprinting gurus. That's an interesting handle. Fingerprinting, you had 9 months, I guess you've been waiting, and that's getting to the point where I would talk to my congressperson. Saints fan. I'm a Falcons fan, so although I went to school in New Orleans, so Saints fans, we're kind of big rivals. Although the Saints, have had the Falcons number for a while, so I'll give you that. I was at Tulane when they had the Aints. People used to wear paper bags over their heads because the Saints were so bad. But then again, when you had the Drew Brees years and the Sean Payton years, they were really good. They're usually an entertaining team to watch. So again, I wish them well, other than when they're playing the Falcons. And with the Falcons, who knows what's going on with it. Had a hearing on Monday. Think things went well. The judge asked for doing past jobs. The vocational manager said no. Get into step 5. Step 5 is part of the sequential evaluation process, and that's, can you do any type of job? So if you can't do past work, that sounds like you may have a grid thing going on there. And if the grid rules you can't do past work, then you would win potentially at the grid rule. So that's probably a good sign, yes, I would say. Melinda Damon, hello from Massachusetts. Hello, I've not been there. You subscribed, thank you. Thank you for the info. Melinda, I've not been there. I understand it's really very pretty in the fall and the spring. That is on my bucket list. Never been to Boston. I would literally like to check that out. So hello from Massachusetts. And I thank you for subscribing. Johnny Mills, thank you. You're welcome. On SSI final review, that means that the case is probably at the administrative level. They're doing their final review to make issue a decision. They've got this bureaucracy where somebody makes a decision, somebody else has to look at it and make sure that it's right. That's what's going on. First app took a year for initial 8 months for recon, 4 months for hearing. That's kind of the standard. That's the time frame I gave you before. Second app took 5 months for approval at initial. There's no requirement that a certain amount of time could take. And again, if you have a case that is, clearly listing level, it could be faster. Could be faster. But I'm glad you got approved. The dude. Pardon me. Hope for the best. I'm sorry about the yawning. Again, I had a long day today, and I played 2 hours of tennis poorly, but I still. Hoping for the best, planning for the worst. That's always, it's like the old Stephen Wright line. Only borrow money from pessimists. They don't expect to get it back. So hoping for the best, planning for the worst. Send an email from SSDI informing the 5th stage of evaluation. Again, that's a good thing that they're moving it along. And hopefully you get a decision next couple of months. Tanya says, hey, Tanya, if things go sideways, you'll need my, well, then you reach out to me. This is how you do it. Free case evaluation. You know how to reach me. So please do. And let me know that you're the dude, because I won't know otherwise. Unless you tell me. If DDS sent my case back to SSA final review, is that good or bad? It just means a decision is about to be issued. So, I can't say if it's good or bad because it just depends. It just means the decision is about to be issued. That's all I can tell you. Okay. Well, dude, just like I said, let me know you're the dude, and reach out to me at ssdanswers.com, or use this contact Jonathan, or just email me directly, ssdanswers123 @gmail.com, and just let me know. So you're HVAC, sheet metal construction worker, 8th grade education, artificial heart valve, 15. Yeah, you got a winning case, so I would love to talk to you, dude. And of course, just again, let me know that it's you. Hopefully you get approved. You won't need me, but if you do, I'll win your case. I think it's a winning case. R. Robinson, the SSA judge selected a previous shot from the military. What he means by that? Well, part of the sequential evaluation process is to eliminate past work. And step 4 is, can you do past work? You can't do it. Then step 5 is, can you do any kind of work at all? And again, if you look at the grids, then not being able to do past work, based on your age may be enough. But if you're not at the grids, then step 4 is just eliminating that, and the burden goes to Social Security to prove you could do other kind of work. So that's something. That's something about the sequential evaluation process is how they do it. Again, the 5-step sequential process is, step 1, not A. Step 1, are you working? Step B is, do you have a severe condition? That's number 3, I should say B. Number 2 is, do you have a severe condition? Severe is really any diagnosed condition. Step 3, do you meet a listing? Step 4, can you return to past work? Step 5, can you do any work? That's the process they use. And if you look at hearing decisions, they go through that. Okay. Message before I get approved, step below. Yeah, and I think what T-Cash is talking about is situations where a file gets stuck on somebody's desk, and once you get it unstuck, they go ahead and approve it. And that's obviously what happened here, which is good. So yeah, I've had a number of cases where I've called the Social Security office and, oh yeah, it's stuck on somebody's desk, or this person is out sick. Well, I got a client who's suffering. Will you take care of this? Sometimes they do. And I think a lot of them want to do it. A lot of these adjudicators want to do it. Okay, you're 63, file for disability after going for early retirement. You qualify non-medical. What do you mean by non-medical? Not seeing if they qualify non-medical. Non-medical is whether you're working. So you could have a severe listing level case, but if you're working over SGA, you're not approved. That's, you wouldn't, step 1, are you working? You'd be denied there. So they're checking the non-medical reviews to see whether or not you have earnings, generally speaking, or something else like that. Johnny says, a friend of mine died, unfortunately, 2 years ago. Went to a hearing with tachycardia and chronic left knee pain. Doctors said they left medical clearance, denied again. I have no explanation. That is absurd. If he had these severe conditions, he should have been approved. Some judges don't seem to get it. Maybe the medical evidence was not properly developed. All these things were not in the record. Part of this is you got to get stuff in the record, but I have no explanation as to why your friend didn't get approved. And unfortunately, he died. And, I think hundreds of thousands of people, 200,000 people died last year waiting. Ridiculous. Aaron, why hasn't SSA updated the asset limit for SSI in decades? It's a money thing. I think that, again, SSI people applying for SSI have not worked enough to pay into the system. They're very low priority in Congress. It's no disrespect, it's a welfare program for people who don't have any earnings records. Congress doesn't care about you, how else to put it. And that's why they just basically make it where, the amount of money you can have or assets, they want to limit people claiming SSI because it is a drain on the system. We got about 5 minutes left. Ms. B. Hello, Mr. Ginsberg. It's Jonathan, not Mr. Ginsberg. Okay. I think I understand your question. Can you explain how SGA works if you applied in August, but your gross for the year is already 30? They look at it month by month. So let's say you earn $30,000 from January through July. And starting in August, SGA 2024, 1550. Let's say in August, your earnings were $1,300. In September, they're going to be $1,400. As of your onset date, what were your monthly earnings? So they don't look at it yearly and divide by 12. They look at it month by month. So if let's say that your onset date was May 3rd of 2024, they're going to look at earnings in January, February, March, April. It'll be over SGA. SGA doesn't matter. In May, you say you became disabled May 3rd. In my example, what were your earnings in May? Were they over SGA? If so, they may need to move that onset date further. What were they in June? You can use that trial work period. But they don't look at the yearly earnings. They look at the monthly earnings. Currently working part-time, pay has decreased as well. Does SGA start from my fall total gross? No, it's month by month. It's based on the month, the onset date, not the date you apply, but the onset date you're claiming. So if you're claiming May 3rd, they're going to look at your earnings after May 3rd and if they're over SGA or not. And again, in theory, you could be over SGA and that could be considered an unsuccessful work attempt because you can say, I was making more than $1,550, but I was getting special considerations or, something that makes it not regular work. I was able to work 5 days from home where nobody else was, something like that. It's a little convoluted, but basically you look at the onset date. I skipped you. Kendra, did I skip you? What did you want to know, Kendra? I'm sorry I skipped you. Did not mean to do that. But I have a Kendra, I have a Keisha, and I have now a Canova. A lot of K's here. A 53-year-old lady wanted to know how long in Florida should I hear back from SSI, fracture my right knee, lower back pain. Florida is going to be, I sense that Florida is one of the states that's a little longer. So I tell people once you get beyond 7 or 8 months, reach out to your senator. I think Florida, and Jen, if you're still on, you can tell me, because you probably know this better than me, how long Florida is, but it's a long time, I believe. Saints fan, I turned 50 2 weeks from my hearing. Group applies, lose my benefits prior to 50. Well, the judge could find you disabled as of 50 under the grid rules and eliminate your past due benefits, or the judge could use the functional capacity and it wouldn't make any difference. So I had this happen to me recently where I had a case, my client turned 55 or 50, I think it was 55, in June, the hearing was in, like early July, the judge approved him as of June, no past due benefits. I don't get paid. He gets his ongoing future benefits after the 5-month waiting period. Those are the breaks. Judge was kind of a jerk anyway, but that can happen. Yeah, absolutely. I got a few more we're going to zip through. What age does SDI, means I think social security disability, switch to regular at full retirement, 66 or whatever? I think this is Deb responding the same way I did. Okay, this is Interesting question. What's the difference between not significant limited, moderately limited, marked limited, the functional capacity form? I generally look at it in terms of percentage of the day. So if it's not significantly limited, you're not going to be limited, let's say more than 10% of the day. Moderately, maybe, it can depend on the form, but, 30% of the day. Marked might be 70% of the day. So I mean, that's a way to look at it, just in terms of percentage of impact on your functioning is usually how that's done. Okay, so Deb says after 1960 is 67. Raymond says Congress not get a case involved in a case goes past the ACA once it's been adjudicated FTC level. Okay, so what he's saying here is that at federal district court, not the appeals council, but at federal court, Congress is not going to interfere because, and this is actually an interesting point, federal district court is judicial, and this is part of the judicial branch. Social Security is part of the executive branch. So before it gets judicial, Congress can inquire and make congressional inquiries because it's an executive function. But once it gets into the judicial branch, you will not have Congress. That's why your congressperson cannot contact your local judge to say what's going on, because it's judicial. It's a whole separation of powers thing. Okay, so we're going to go through just a few more here. We've got a few thank yous here. And thank you very much for wisdom. My pleasure. Okay. LJ canceled my hearing, issued fully. That's great. I've had that happen a few times. That is really, really nice. LJ just canceled my hearing. Favorable decision. Great. I know CDR. Good. Thank you. I'm appreciated. Well, it's good to be appreciated. The judges consider muscle relaxer. Yeah, it's not as significant as pain medication, but it is, it is a medication that can have side effects. Nothing. What is 9% approval of the blue bar? It means nothing. Okay. If you found unfavorable decision of appeals, you don't win. Do you reapply? You could appeal. I would exhaust the remedies and go to federal court, at least talk to somebody about going to federal court, but then afterwards you might reapply. Although I would not again, you have to look at your date last insured, but if you reapply right away, it's going to be hard to say something has really changed. James McDougall appreciates thank you very much, James. I really appreciate that. Good morning from Budapest. Wow. Thanks, Shannon. I had a client in Vietnam. Never had anybody from Budapest. That's awesome. It's one place on my bucket list as well. Actually, a friend of mine was there the last couple of weeks, sent some beautiful pictures. So I've heard it's really, really nice. You have to tell us about Budapest sometime. LJ here, made a decision, 2 jobs, mental health. Again, if the vocational, the more times a vocational expert says no jobs, the better. All right, we're going to end it on Christina's comment. Please do not forget to like, share, comment, and subscribe. I will second that. Thank you, everyone, for joining me. See you next week. And one programming note, it will not be next week, but the week after, I believe it's September 11th, I'm going to move this, I think, to a Thursday. My wife made some plans, and the only day we could do it was on Wednesday. So I'm going to do it on the 11th, and I'll put this out there. But on September 11th, I'm going to do it on a Thursday. So not on Wednesday, but I'll put this out there. But just if those of you who are regulars, if you're interested, just keep in mind that on September 11th, it's going to be on a Thursday. Not Wednesday the 11th, it'll be Thursday the 12th. So anyway, but I appreciate everybody's attention here. I enjoyed talking to all of you. And again, if you can, leave me a nice review. Go to jonathanginsberg.com or just go to that review that I've been posting before. And again, free case evaluation, you know how to do it. Contact me at contact Jonathan 3. So I'll end it now. Thanks, everybody. Have a great week. Stay cool and enjoy and be healthy. Thanks a lot.